Let's go live. Okay, so I believe I'm going live. We are on. So welcome everybody. Let's see. I'm gonna make some. If you're watching this and it's pre-recorded, it's gonna start like in 5 minutes while I adjust the settings for it. So welcome everybody. What I do want to do today is I want to, for a second aside, I want to make this microphone work. So Zoom is a little tricky because I do use Zoom. The tricky part about it is the audio connection. So camera angle seems okay. There's the there is the microphone. Now what I'm going to do is I'm going to tap on this microphone. There's an option for microphone. I just didn't want to plug it in earlier because, like I said earlier, this is a little bit tricky as far as the sound and the microphone. I want to get this right. By the way, my name is Edward Paul Reyes, and
I am a bar tutor and an attorney in California. Okay, I'm distracted. Obviously, look, the screen left us. Why did the screen left us? Why did the screen leave us? Can you guys even hear me? Okay, there I am again. So, let's see now. So I think you should be able to hear me because it says here, select the microphone, and this is this microphone here. Okay. And then it says select a speaker, and it should be the same thing. So I hope you guys can hear me. If not, then I'll just be babbling. Okay, so great. Is anyone there? Can you guys hear me okay? By the way, I am one of the reasons why I'm using Zoom is because I want interaction. I know that many people have questions about the essays, so I want to just be here until February, until the exam approaches, and yeah, I'm just gonna be here because I really enjoy tutoring. I believe it or not, I love the California bar exam. It's very challenging. It's definitely a challenge, but it can be done. I did make a post on Facebook and I said, hey, look, one of the reasons why the bar passage rate is lower in February is because pretty much you have people who were not successful in July, right? And they were doing something wrong. And that's why they didn't pass. And so what happens when they retake it? Many of them will still be doing the same thing, expecting the same results. And that is not something that you want to do. And I am referring to the 1 hour essays, right? I have had people who I've tutored and they've increased more than 100 points. Right now, sometimes people, even though with that amount, they still can't pass because there's also the MBE, right? And also people have employment or a family or right. So there's all these factors. So it is a very challenging exam, and yeah, and you have to. There's a mind shift that needs to occur. And yeah, it's very rigorous, but it can be done. So let's go ahead and I do want to grade a crimes essay. I am going to do that. And I'm going to share my screen. Okay, so let's go ahead and do that. Let's look at the essay. Let's first share the screen. Let's go ahead and do that. Share screen. I love sharing the screen because you guys could see. Also, I want to make sure that you guys can see this. So what I'm going to do is I'm going to increase the size here of the font. Okay. So let's look at the call of the question. By the way, this is from February 2008, crimes. It says, may Dan successfully move to exclude the statement under the Fifth and Sixth Amendment. So that's very common. And can Dan be convicted of murder or of any lesser included offense? So notice how broad that is. Oh my goodness. Can he be convicted of murder? Notice that they're using common law murder, right? Because what do you have in modern jurisdictions? You have what? First degree, second degree. So yeah, it's very broad. So let's go ahead and look at the let's just look at this at the let's look at the hypothetical. Let's look at the hypothetical. Let's see now. It says here. Give me a second here. By the way, I'm going to look for, let's see now. It says, okay, so Dan's neighbor was overrun by two gangs, the Reds and the Blues. And I'm just going to skim over this. And the Reds tried to recruit Dan to join his gang. So Dan, when it starts with the D, so that's going to be who, for these hypotheticals, the defendant. When the defendant refused, Vic, and Vic sounds like he's going to be the victim. Vic said he couldn't be responsible for Dan's safety. So something's going to go down, you guys. I don't know what's going to happen. So after threatening Dan for several weeks, Vic backed Dan into an alley, showed him a knife, and he said, think carefully about your decision. Your deadline is coming fast. And Dan was terrified. By the way, I do want to give tips on issue spotting, because there's a lot of words here that you want to use. For example, when they're in parentheses, all right, you kind of want to, sometimes there's the bar examiners are saying, hey, look, we might want you to use this language. And there's other language as well, that what I call juicy facts. For example, Dan was terrified. So think about that. Dan was terrified. What are juicy facts? Juicy facts are usually adjectives or nouns, and they usually have some kind of meaning within the hypothetical. Like, for example, Dan was terrified. So if you see something like that, you would identify that. It's a technique that I use, and I'm not going to go too much into that here. But yeah, it's these little keywords that can really boost your score. Another example here, he began carrying a gun for protection. So for protection. Okay. A week later, Dan saw Vic. Okay, with his hand under his jacket, afraid again that Vic might be about to stab him. Dan shot and killed Vic. You see what's going on there? There seems to be some kind of murder, but then we get the state of mind that Dan was experiencing at the moment. He was afraid. Right? They're telling you he was terrified, and if you don't use those key words, and then you're just saying, hey, look, I'm not maxing out on points here. I'm not, right? I can do better. So, right, I want you to use these little keywords because, yeah, they can mean a little 5-point difference, and that goes a long way. Dan was arrested and put in jail. And after his arraignment on a charge of murder, an attorney was appointed. Dan received a visitor who was a member of the Blues. His name was Sid. Sid, the Blues wanted to help Dan. They hired him a lawyer. Let's see now. Sid said the lawyer wanted Dan to said exactly how the killing had occurred. So you see there he's talking to someone. And Dan just said, hey, he shot him to win the harassment. Dan later learned that Sid was actually a police informant. Okay, so do we have a police agent there? A government agent? Do we have that there? Okay, so let's go on. And by the way, thank you for these essays that you guys are sending to me. I do appreciate it. I am reading them. And yeah, I want to, I thought this was a good, I thought this was a, and I'm just gonna, okay, let me stop share here and I'll go back and forth. I thought this was a good essay to review because it does have that structure that I want you guys to use, that E plus B plus F, right? And that's something that you guys want to do repeatedly to the point where it's really mechanic, E plus B plus F. And this writer here does a good job. Now, I don't want to say that it's a passing score yet because I have not reviewed it, but when you see something like that, E plus B plus F, and I'll show you guys what I mean, element plus because plus the facts, then that potentially could be at least a 65 if they have a proper counter argument. Okay, so I'm just going to put here what I'll be looking for. Let's see now. I'm going to put this in blue, bold. I'll be looking for two things. Number one, the structure that goes, all right, for the basic analysis, the element plus the word because, and then fact. Okay. And we'll see, not face. I put face. Okay. And then also, do we have a counter argument? And of course, you guys, I'm going to say this over and over again. Don't stop at the counter arguments. Don't stop at the counter argument. Because let's say, for example, if you have this structure for your analysis, elements plus because plus the facts in the fact pattern, and you have one counter argument, I mean, yes, that can get you a 65. What I'm saying is that why would you want to stop there when you can make it a 70? How do we make that a 70? You do a rebuttal to the counter argument. Okay, let me stop here and let me quickly say something to just emphasize this point. Let me do an analogy. Okay, when you guys go out and practice, right? Once you get licensed, and let's say you do a complaint, for example, right? And your client says, "Hey, look, there are new facts that I want to present to the court that were not reasonably available at the time. Can we amend the complaint?" And the opposing party, you've properly served the complaint, and the other party has responded. They filed an answer to the complaint, and right, more than 30 days have passed since you initially filed. So, in order for you to file that complaint, what must you do to file the amendments? Right at that point, then you do have to ask the court for leave to file the amended complaint. So let's say that your motion is the initial argument, right? That's going to be, I'm going to submit in this motion for the court to grant leave to file my first amended complaint. The other party is going to say, "Hey, look, I do not want the first amendment complaint because it might be prejudicial to my clients. So they're going to file an opposition." So think about it like that. That's the counter argument. You guys see that? So what you are doing when you just write a counter argument is you're just doing exactly that. You're writing a motion, then you're writing the opposition, writing an opposition to your motion. Think about it like that. But in actual practice, if you're the plaintiff and it's your motion, do you want to stop there? The answer is no. What do? You file a reply to the opposition. You see that? So think about the reply to the opposition. Think about that as the rebuttal to the counter argument, right? For bar exam purposes. So you see that could get you a 70 if you. Okay, let me stop there because I know it's a lot of information. So let me go ahead and continue to share my screen. Let's go ahead and share the screen. By the way, I'm getting better at this technology. I feel much more comfortable with it. Put it that way. Okay, so I'm going to be looking for this element plus because plus facts, and I'm going to be looking for a counter argument and maybe even a rebuttal to the counter argument. Right. Okay. And by the way, as I've said before, the essays that score 100, they have that rebuttal. Or, okay, let's just stop there. Let's keep going. So this bar candidate states, hey, look, it's Fifth Amendment. Okay, got it. Privilege against self-incrimination. Got it. I mean, I'm really focused. I really wanted to discuss the Miranda rights under the Fifth Amendment and maybe the right to counsel under the Sixth Amendment. So this, I mean, it's okay. It's like more of providing a background, but I'm not going to be too focused on that because that's not where the main analysis is found. So it says under the Fifth Amendment, none should be compelled to testify against themselves. Okay, so the right against self-incrimination. Okay, so that applies both in civil and criminal. Got it. Got it. You see that? I mean, there's not much there to analyze. Okay, here Dan was induced to give self-incriminating testimony. Okay, see, I'm not really. Okay. You see how this is more of a conclusion, right? I think first you want to discuss Fifth Amendment. First, you want to go to the analysis of whether he was in custody, whether it was an interrogation, right? Before you kind of make this conclusion. So I would consider, I see what you're doing here, but I would even consider not having this. Just go straight to Fifth Amendment, especially when you have a second part of the question that deals with murder. It's time restraint here. So you have to economize your time. Okay. But let's go ahead and read it. Okay. Let's hit self-incriminating statements. You see how, okay. I don't want to get too much into this. Okay. So it's just, I'm just going to consider this a kind of just like a background to the actual analysis. Because you see, look, in conclusion, Fifth Amendment privilege against self-incrimination has been violated. But how do we know that without first going through the analysis, through the Miranda rights analysis? All right, so let's not jump the gun here. Okay, so here's where it gets, here's the meaty part to this. Under the Fifth Amendment, any incriminating statement obtained in the custodial interrogation is inadmissible. You guys already know this. I'm just going to skip through this. The custodial element is met. Okay. I really like how this bar candidate, he or she used quotation marks. And why do I like that? Because I have a feeling they're going to focus on that. And I think that's something that's really not always talked about. But when you do your analysis, you guys, right, you have your issue and you have your elements. And this is what I'm talking about when I mention E plus B plus F. Do you discuss the elements? For example, is the person is in custody because this fact, the person this is an interrogation because, right? So if you put it in quotation marks, if you underline it, if you convert it into a bold format, if that helps you to write in this format, that's great. So I commend this writer. Okay, so let's see now. Okay, so let's just keep going here. I'm not going to focus too much on the rule statement. Okay, so here, again, a signal word. It says D, look at this. He was in custody. Boom, right there. You see that? The structure is proper because, boom, E plus B plus F. You guys see that? He was arrested and put in jail where a reasonable person would have assumed that they are not free to leave. Okay, so they're using the facts. Also, oh, great transition word. I call these signal words. Okay, fantastic. See, this is to be, it's looking like it's a passing score, right? Okay, Sid, the police informant, was asking him questions that were likely to elicit incriminating statements. So I think he or the writer is going into interrogation. All right. So you want to keep these separate. I mean, I could even do this. put a space, right? Because they're different. They're different elements there. Don't overlap the elements. Don't overlap them. Okay, so I mean, okay, so let's just read. Let's just continue reading and see if we find a better structure. Okay. Now I'm just gonna skim through this. Incriminating statements. Okay, likely to elicit an incriminating statement. So I really like this. Let's start here. Sid was specifically asking D how the killing occurred, which is likely to elicit an incriminating statement as it relates to the crime. Okay. Since D's conversation with D was likely to elicit an incriminating statement, you see what's happening here? It seems disjointed. The discussion seems disjointed. Here's how this writer could improve the just the overall format of this, the presentation, make it sound more concise, more solid. Look, remember this, you guys. Remember what I said at the beginning? E plus B plus F, element plus because plus fact. So what I suggest is that use, okay, signal word also. Okay, there is an interrogation or, okay, so let's first find the elements likely to elicit an incriminating response. Do you guys see that? I'm gonna use the color, this color here. Okay, so he's already discussed the custody part. Now let's discuss the interrogation. Okay. Now we can say this also, and I'm gonna just use E plus B plus F. I'm just gonna use that. Okay. Also, let me see. Let me go ahead and just that. I'm gonna just be mechanical, you guys. Be mechanical. Also, the state had the intent to elicit an incriminating response from D because, right? E plus B plus F. This is what the writer is getting at, incriminating statements. But you see how that's more clear? Because, and then you go on to state the reasons. Let's go ahead and just do it very quickly. Okay. Because Sid lied to D that okay, look at the analysis here. It's the facts. Look at this. You know what? Well, you know what I'm gonna do? I'm gonna copy and paste this. Because paste, boom. Because Sid lied to D that he was on his side. Look what I'm gonna do now. I'm gonna do another signal word. Moreover. Okay, now what else does this writer present? What's another reason? Sid was specifically asking D how the killing occurred, which is likely. Yes, look at that. Yes. Okay, so this goes towards the element of an eliciting and likely to elicit an incriminating response. I'm gonna just copy and paste this. Literally, just copy and paste it. You see how now, moreover, Sid was specifically. You see how now it just kind of has that better flow. Okay, so E plus B plus F, you guys. E plus B plus F. Okay. Now let's go ahead and see if there's a counter argument, because remember, that's what I said I was going to look for. Okay. Since these okay. The conversation between Sid amounted to interrogation. There is no indication that at any point D was informed of his Miranda rights, since D's conversation with D constituted custodial interrogation without informing D of his Miranda rights. D can. Okay, so I didn't see a counter argument, which is maybe fine. Maybe there's a counter argument here under Sixth Amendment. Okay, so I am looking for that. Okay, so just to recap, okay, we're on page 2. Just to recap, I'm looking for this structure here and then a counter argument. Let's go ahead and look at the Sixth Amendment analysis. Under the Sixth Amendment, any defendant has a right, okay, speedy trial, the right to counsel. I'm not going to focus too much on the rule statements. Okay, let's see now. Critical stages of investigation. So the Sixth Amendment right to counsel attaches at critical stages of investigation. Got it. Great rule statement, by the way. Let's look at the analysis here. Critical stages. Oh, nice. You guys see that? E plus B plus F. I'm going to focus on that. I'm going to focus on that because you see that? Fantastic. Fantastic. So maybe this could be a 65 response. But I'm not going to say that it is a 65 response because even if you have E plus B plus F, right, does not necessarily mean that it's going to be 65. And why do I say that? Because usually for a 65, you do need that proper structure, but you also need to address counter arguments. And has this writer addressed counter arguments? Not at this point, so I'm not sure. Okay, so anyway, let's keep going. Give me a second, please. Let's see now. Share screen. Share screen. Okay, here we go. His arraignment had already occurred, after which he was appointed an attorney. Okay, however, when I see the word however, I'm gonna think, wow, okay, great. This is critical here. Okay, critical stages. Let me use another word. This is important, right? To make a determination of where the score is heading. Okay, let's see now. So, however, I get dramatical. I mean, you have to, right? You got to take these words that they mean something. However, his attorney was not present when Sid, the police informant, was asking him questions, interrogating him. Since his attorney was not present, Sixth Amendment right to counsel has been violated. Okay, I appreciate the counter argument, but I'm going to tell you what is wrong with this counter argument. I don't want to say what's wrong. Let me use another choice of words. Let me show you how to make this stronger. Okay. Because when it comes to making the counter argument, there's a little trick there. Okay, it's a little trick. Here's the trick, you guys. Remember how we used E plus B plus F? So for the counter argument, you have to use the same element as in your initial argument. Let me give you an example. It says here, right, the critical stages of investigation had commenced. Because, so what's the element? Critical stages. So that means that for the counter argument, we have to discuss critical stages. You guys see that? And that right there, what I just said is it tends to confuse a lot of bar candidates. It tends to confuse them. Why? It just does, right? One reason is because candidates come in right to the approaching the exam with preconceived notions of how to write. Maybe they've read the bar, the model answers, and they generated a conclusion about how to write. So it's already in the back of it. They're now writing unconsciously, right? Subconsciously, they're writing. So in order to stay consistent And to use the same element, it's going to take practice. It's going to take repetition. And in my experience, that's been one of the key points here that I consistently address with the candidates that I tutor. Okay, this right here is a perfect example. Okay, so let's go ahead and write a different. Let's go ahead and write a different counter argument. However, using the same elements. However, the state will argue that I'm just going to be mechanical. E plus B plus F. That critical stages of the investigation had commenced or not commenced. Had not. I'm just going to emphasize that commenced. Right? You're taking an opposite point. Because why? Why had they not commenced? Because Sid was not in police uniform, for example, right? You could just, it has to be reasonably connected. I'm just using this as an example. Is one sentence fine? Yes, that's fine. Okay. So you see how I use the same elements, critical stages of investigation, right? That's going to be key. And then of course, when you rebut that, and then, okay, let's do a rebuttal. Okay. I just like to use the same mechanical language here. This is a close call. However, a court will probably agree. There's the rebuttal to the counter argument. Agree that critical stages of the investigation had begun because, as stated above, then Sid's questions were actually interrogations. Okay, Sid's questions could likely incriminate, could likely lead to self-incriminating responses from Dan. You see that? That right there? You guys see that? That rebuttal there, that could get you a 70. If you do 2 of those rebuttals, that could get you a 70. And that's what I always argue. I'm like, hey, look, find out first. Okay, there's steps, of course, right? But you do want to get to the point where you are you have the intention, of identifying at least 2 points of contention, 2 points of dispute that you can turn into a counter argument. And then, right, you can make that structure with the rebuttal to the counter argument. If you find 2 of those and you write 2 of these counter arguments like this, you're looking at a 70. If you don't believe me, look at baressays.com. Right. By the way, I have a code. Let me see if I could find my little chart here. This is my bar essays. Bar essays discount code Jurex bar. Okay. Baressays.com. Okay, so shout out to Bar Essays. All right, let me go ahead and continue to share my screen. La 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 la. Okay. I always get mixed up with all these buttons here. Okay. Now, okay, so that's what's going on there. In conclusion, Sixth Amendment rights have been violated. Okay, got it. So let's continue. Exclusionary rule. I'm not going to focus too much on that. Okay, but you do want to, there's a format there for the fifth and sixth um, amendment issues. You do want to mention the exclusionary rule, right? Okay, so I'm not going to focus too much on this. Let's go ahead and address murder because this tends to be tested repeatedly. Look at this. I want to show you something. Can Dan be convicted of murder or any lesser included offense? Again, that is very broad. So how do you even deal with murder? I think murder, from my experience with as a bar candidate and as a bar tutor, it's one of these issues that you want to, what I call, you want to put your foot down on. You want to, for example, like the exceptions, exemptions, there were two hearsay. What is non-hearsay? You kind of want to say, hey, look, stop. I'm going to just put my foot down and I'm going to understand it. Okay, so let me show you guys something very quickly. So I have the cheat sheets here. Right. Let's see now. So there's murder at common law, first degree murder, second degree, voluntary manslaughter, involuntary. So see how broad it is? So you got to have a solid definition for all of these, especially when they ask you a question that's very broad, right? For example, murder. So what do you do? Do you discuss all of them? I think I've seen one essay exam where, the person had to discuss all of these, or most of them, right? But what you usually want to do is, if you want to be responsive, what does that even mean? Okay, you got to consider how much time there is. You got to consider the facts. Where do they tend to lead to? Right. Because sometimes it's just not, it's unreasonable to discuss all of these issues under murder. So, by the way, my cheat sheets, I'll just post the code. I'll post the code, the link in the description. They do come with the 7-day money back guarantee. Anyway, let's go ahead and look at how this bar candidate approach the murder issues. Okay, so it says first degree murder is killing of another with premeditation or deliberation, or felony murder. Okay, so here's what I suggest. Let me tell you what I suggest, and then we'll see how he or she analyzed the issues. Let me see, because I'm already confused. Why am I confused? Because it says with premeditation or deliberation, right? That usually goes towards what, you guys? What kind of type of murder? It goes towards, okay, so first degree murder. Okay, so he's right on point, right? He's right, or he or she is right on point. Okay, so first degree. Look at the call of the question, though. Look at the call of the question. Convicted of murder. It doesn't say first degree murder. You see that? It does not say first degree murder. So what are they getting at? They're usually getting at common law murder, right? Or any lesser included offenses. So in this situation, here's what I will suggest that you do. Okay, you quickly discuss murder, common law murder, right? Intent to kill, or actually malice, right? That's what it is. Intent to kill, great bodily harm. And I usually put felony murder as well. Okay, why? Because I put my foot down. And there's really no way to say, hey, look, this is the correct format. No, it's not, because of course there's so many jurisdictions and they have adopted their own terminology, right? But this is just the kind of the bar exam kind of style, right? And then after this, after you discuss the relevant issues on the murder, and then you go on to discuss the lesser offenses, which could be first degree murder, right? That could be one of them. But Yeah, it's deliberate and premeditated. So this writer is right on. It's as far as using their keywords. By the way, can you guys see this? Let me see. Let me go ahead and yeah, hopefully you guys can see this. I do want you to see this. Okay, the little right these. Okay, these the fine print. I want you guys to see the fine print. So first degree murder. Let's go ahead and see how he or she or how this bar candidate analyzed it. Premeditation of deliberation or felony murder. So you see already it's become a little bit confusing there. Okay, the intent of premeditation. Yeah, I'm already confused by this. Don't overlap, you guys. When you guys have, just deal with them one at a time. Don't overlap. Okay. Here's what I do. La 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 la. Text. It says, I'm just gonna okay. The intent of premeditation does not have to happen. Okay, so that's the rule statement. Then you have felony murder here. Okay, during the commission of what bark is that what it is? Burglary, arson. Okay, there are various offenses. I'm just skimming through this. Prevent. Okay. Defenses talks about defense, self-defense. Great, which is I think is going to be key here as well. Okay. D was not the aggressor. Let's look at the analysis. Here, D did kill Vic. Okay. What's wrong with this, you guys? Here, did D kill Vic? Okay. What's wrong? What's wrong? Okay. Well, I'll tell you what's going on here. Okay. So remember how at the beginning I said, hey, look, focus on E plus B plus F. So instead of saying he did kill someone, what would be a better choice of words? Right here, it was deliberate, right? You want to use the elements, because if you do not use the elements, and then it makes the rule statements, it just makes it irrelevant. It's just why did you write that rule statement if you're not going to analyze it from using those those elements, right? You guys see that D did kill. So instead he could have used, there was deliberation and or premeditation, because okay, then they go into the counter argument, and this I find this troubling already. Why? Because remember what I said about the counter argument. You want to analyze an element in the initial argument, the premise, right? And then you want to carry that same element over until for the counter argument discussion. But how can you do that when your element is not solid, when it's weak? You guys see that? So I have a big problem with this counter argument being here. Okay, however, D will likely assert self-defense. Okay, so I guess that's a good place to, it could work, but since there's the elements haven't been properly discussed, I think it's premature to discuss self-defense. Do you guys see that? Okay. D will argue the shooting Vic was reasonable. Okay. D will also likely be successful. You see, I'm just kind of skimming that because it's the foundation there is improper. In conclusion, D will most likely assert self-defense. And I'm sure the conclusion is great, right? But the analysis, that's where this is the part that counts the most. Okay. Second degree murder, common law. So they are being responsive. They are discussing lesser offenses here. Okay, common law murder. Okay, so now they discuss common law murder, right? Whereas I had it. My structure would have discussed common law murder at the outset, and then discuss first degree murder. Like I said, there's no one way of doing it, as long as you're consistent. I mean, if you discuss first degree murder, second degree murder, and then you discuss common law murder, you do that, you have a good grasp of that, that's fine. what I tell my students is that there really is no one format, but as long as you are organized. So you right, this is a presentation. This here, your writing is a presentation. Okay, second degree murder. Common law murder is unlawful killing of another. Okay, so with malice. Okay, so we discussed that earlier. It exists. Intent to kill. Got it. Severe bodily injury, reckless indifference, felony murder. Got it. Got it. As discussed above, D did not have the intent to kill, rather, okay, self-defense. Okay, so, okay, so there's a quick discussion. I mean, sometimes a quick discussion is fine as long as you have a solid analysis somewhere in there, right? In this case, I think the writer could have done a better job at analyzing one of these elements. Okay, manslaughter, heat of passion, got it. Okay, let's go ahead and see how it was analyzed. Will not be successful with the heat of passion because he was not in any heat of passion as there was no adequate provocation, either objectively or subjectively. Okay, so, okay, let's look at the rule statement here. Heat of passion. Okay, the adequate provocation. Okay. Okay, so let's assume that he or she is discussing adequate provocation. Okay, let's see now. There was no adequate provocation. Got it. What's the reason? Enacting as there was no adequate provocation. So there seems okay. Remember what I said, you guys: E plus B plus F, element plus because plus facts. So here we have the elements. What's missing? Because the facts. So what do we call that? We call that, what is that? Circular reasoning. Okay, it's conclusory. That's what it is. It's conclusory. It's saying, hey, look, there was no adequate provocation. There's no reason offered. Okay, so it's conclusory. So that's not proper. Then they go into a counter argument. Again, remember what I said? If there's no there's no discussion of a clear element there, which here I'm not, I think it could have been no adequate provocation. I mean, that would have been perfect. However, he may be successful in arguing that he honestly but unreasonably believed but unreasonably believed that he needed to kill the victim to defend himself. So overlapping the issues, what issues do we have here? Honestly, but unreasonably believe, right? He was acting in self-defense, but here we're talking about adequate provocation. So you see how it's already starting to just, all these elements are starting to jumble up. It's okay. It's not clear. That's why I always repeat element plus because plus facts. Carry that element in your initial argument onto your counter argument, and then it's very clear. Okay. In conclusion, D is likely guilty of manslaughter or the first degree. Okay, so the person started off strong. There were some great points. I did point those out. I think this could have been, I think the score here is a 55, close to a 60. Why? I'll tell you why. Why could have been a 60? Well, let me say this. I think the first part was a 60. The first part here was a 60. However, there was no clear counter argument, right? So could it still be a 60? Sure, it could still be a 60. Okay. Now the second part here, I think there was not a proper discussion as to the elements. Even though you had counter arguments, they had to be proper counter arguments. So this kind of dropped, right, the score to a 55. So that's why I said at the outset, hey, look, I'm going to focus on this format here and the counter argument. Right. I did say that. So, yeah, send me more essays. I did get more essays. So I do appreciate that. And again, I enjoy looking at these essays. and I want to keep doing this. So I hope you got some benefit from this, and yeah, keep at it. It is going to take time. It is going to take practice. It is going to take repetition, but it can be done, and you're gonna get to that level. Okay, so with that said, let's see if there's no questions. With that said, I'm going to end this live stream. And again, thank you for watching, and I wish you all the best. Let's see now. End the stream.